So, good morning and welcome to the National Press Club, the place where news happens. I'm Tara Kopp, Pentagon correspondent for the Washington Post, and a board member here at the club. Our guest this morning is Charlie Baker, president of the NCAA and former governor of Massachusetts. Charlie took the helm of the NCAA in 2023, and I think it's safe to say he's overseen a tenure of unprecedented change in college athletics ever since. And we're very grateful for you here. We're very grateful for you being here today with us, especially because we're just 3 weeks out from a historic settlement called the House Settlement that has really been a game changer in how student athletes will be retroactively compensated and going forward, how they will be compensated in their future collegiate careers. So we're super, super grateful to have you here with us today. And I think just for our audience members who don't really know about this $2.6 billion settlement that happened on July 1st, if you could please just start with walking us through that and how it really changes the scene.
Okay, so first of all, thanks for having me here. The House settlement is shorthand for 3 lawsuits: the Carter case, the Hubbard case, and the House case. And they all go back a variety of years. The House case probably goes back the farthest. So think of it as sort of somewhere between 8 and 10 years worth of litigation between the plaintiffs and the NCAA. And the NCAA is one of 6 defendants, okay? The other 5 defendants are the SEC, the ACC, the Big 12, the Big 10, and the Pac-12 is actually one of the defendants in this case, at least for the back damage piece. The argument of that case was about Division I sports, okay? So this isn't about Division II and Division III. So there are 1,100 schools in the NCAA. There are 500,000 kids who play college sports. 2 of mine played D3 football. This is really about the 150,000 student athletes who play in Division I, which has about 365 of the 1,100 schools. So this isn't all of college sports, it's a piece of college sports. And I'll narrow it down a little more as we go. Both of the Hubbard and the House case were both on a track to start trial sometime in the year we're in now. There were a series of negotiations between the plaintiff attorneys and leadership on our side in sort of call it the summer of 24. And we eventually reached an agreement. And that agreement has 2 parts. It has the back damage piece and it has the go forward piece. And in the context of the discussion between the plaintiffs and the NCAA and the other defendants and the court, where this landed was the NCAA basically owned the back damage piece. So that was negotiated out as a $2.8 billion payment over the course of 10 years to the class that filed these suits in the first place. Roughly 99% of the members of the class signed up to get those payments. It's a $285 million check every year that gets written by the NCAA for the next 10 years to pay those back damages.
Does every athlete get the same amount in that settlement?
No, but that's up to the plaintiffs. We have no role in that. They make the call. On the go forward piece, there's a structure that's put in place to do 3 things. Number 1, make it possible for schools to spend up to 22.5%. I apologize right now for the complexity of some of this stuff. The go forward on this is gives schools the ability for the first time to spend up to 22.5% of the athletic budgets of the schools in the A5, the former 5 power conferences, 70 schools, to spend 22.5% of the blended average of all of their athletic budgets. So think about that as you take the athletic budgets of those 70 schools, you add them all up, you divide by 70, and that gives you the average. You then take 22.5% of that number, and it creates what the first year eligible opportunity to spend looks like, which is basically $20 million that you can spend on institutional NIL. It goes up by a certain percent every year, and then it gets renegotiated or redetermined based on changes in media rights contracts, ticket revenue, or whatever else might be going on every 3 or 4 years. For 10 years. The other piece of it is third-party NIL deals, which has been sort of, for all intents and purposes, the only kind of NIL deals we've had up until now. They now need to go through a process themselves, and the process that they go through is being managed inside this injunction by the 5 power schools through something called the College Sports Commission, which is a newly established entity that's going to worry about 3 things. 1, people's adherence to the rules and the filing procedures associated with the institutional NIL program, the 22.5% cap. The program associated with filing and getting approved third-party NIL deals. And then the third piece of this is management to the roster cap that's associated with each sport that's attached to those schools that opt into this. Now that's the next piece of this, which is all schools in D1 don't have to participate in this if they don't want to. They can just stay as they are, not do institutional NIL, and continue to run the same kinds of programs they've always run before. There are basically 319 schools of the 365 opted in the first year. You get to make the decision about whether to opt in or not every year.
Every year. So if a school changes its mind, it can
change to opt in, it can change to opt out.
So
and they go back to, if you opt out, you go back to the way things were. If you opt in, you are now required to submit your information if you're providing institutional NIL to your student athletes, to the CSC's cap management program, and if you have third-party, everybody has to put their third-party NIL deals through this third-party NIL process.
So let's start with one
And the
of
whole
the
thing
pillars.
lasts 10 years and was approved by Judge Wilkin, and it's been in place for 3 or 4 weeks, and everybody's already decided whether they think it's going to succeed or fail, which is fascinating to me.
So that's actually one of my first questions for you. What do you like about this settlement, and what do you not like?
Well, obviously I like all of it because it's, we signed it. I guess I would say a couple things. The first is I like the fact that there is now process. I like that a lot because, I'm looking around this room to see if a particular reporter is here, but I remember talking to a reporter about this stuff about a year ago, and this reporter said to me that they did not write stories about NIL because they didn't believe anything anybody said about anything. One of the great challenges for student athletes, families, schools, is there is no data on what's actually happening. Mm-hmm. There's a lot of alleges, but in terms of real information, there's basically none. So from my point of view, the fact that you're now going to have 2 processes that everybody's got to run their stuff through, and the ability for the CSC to produce data that will tell people, it'll be anonymized, right? But it will tell people things we don't know right now. Like how much really are a lot of these NIL deals worth, depending upon what sport it is and what position somebody plays. And that will give, among others, parents and families and kids the ability to have some idea about whether what somebody says to them about what might be out there for them is real or not. So that's number one. There's going to be more data and more transparency and more process accountability than there's ever been. I think that's a really good thing. The second thing it does is it moves a big piece of the center of gravity away from third parties who are, for all intents and purposes, somewhat invisible and thoroughly unaccountable, and totally driven by the opportunity to make money on transactions, and gives the big piece of the center of gravity to the schools, who have reputations to defend and a desire, I believe, in many cases, to try to figure out some way to create a relationship a holistic relationship with their student athletes at the schools that opt in. So I do believe there will be agreements. I think they'll include academic elements, they'll include athletic elements, they'll include development elements, and it will give the schools back some of the responsibility and authority that they've lost to these third parties. And most schools are not that interested in running a transaction shop, which is pretty much what NIL has been for the past couple of years. I think in the long run, that will be better for student athletes, and I think it will certainly be better for everybody who actually wants to know what's actually happening. Because right now, you have to believe people who have no reason to either tell you the truth, and you have no way to actually figure out if what they're telling you is true anyway.
So let's talk a little bit about that transparency with the 20 million cap in place right now. Will that information be public? Will someone be able to look and see how a university spread that money among its athletes? And can a university promise a student athlete, we're going to pledge you this much per year on a recurring basis, or is it just, it's a single year promise?
I mean, they'll be able to do 1 year, 2 year, 3 year, 4 year agreements. And then it's going to be up to the student athlete about whether or not they want to sign that kind of agreement or what kind of terms they would want around that kind of an agreement. I think there'll certainly be a lot of data that will be made public, but I also believe that student-specific data won't be made public. So the question will become, and this is going to be up to the College Sports Commission, not to the NCAA, they're going to have to figure out where to draw the line between what should be publicly available for the public good and what should be retained as private information on behalf of the student athletes.
Does it depend on whether it's a state university or a private university?
State by state law has some impact on how people will handle that, yeah.
Okay. And then one of the aspects, we haven't really touched on this yet, but one of the aspects, if they're students and they're being paid by the university, there's been some question as to whether or not they would be considered employees. And can you talk about the concerns or risks there may be to identifying them as employees, and what's the hesitation against allowing them to be identified as employees?
Well, first of all, most of the student athlete organizations around the country have made pretty clear over and over again that they don't want to be employees for a lot of reasons. I mean, I talked to thousands of student athletes, and I can just tell you the vast majority, maybe even, I don't think I've ever talked to one who wants to be an employee, but I'm not sure that everyone I've ever talked to has ever talked to me about that. What they really want to be are students who play a sport. And the reason for that is even among the most significant programs, a lot of those student athletes don't think they're ever going to play professionally, and they view their opportunity to play that sport and perhaps receive NIL money for doing that is a really great thing, and the $4 billion in scholarships and everything, room and board and training tables and academic guidance and all the rest, they know at the end of the day they're going to need to get a job and launch, and they don't want this athletic thing to mean more than their time as a student.
But is there concern?
And there's all kinds of other things that come with being an employee. I should let them speak for themselves on this. I mean, you should feel free to talk to them. I'm telling you, the vast majority of them don't want to be an employee. They love the NIL program. They don't want to be employees.
Are there any concerns within the NCAA about the student athletes unionizing?
Again, you know, there's been two. There was one in California, one at Dartmouth recently, both of which have been withdrawn. The kids at Dartmouth tried really hard to get other folks at Dartmouth to join them. They didn't. They tried to get other folks in the Ivy League to join them. They didn't. They tried to get other D1 programs around the country to join them, and they didn't. This is not a fundamental thing that student athletes most of the time, at least the ones I talk to, talk about.
Okay. Well, because we're just 3 weeks since the settlement has been reached, it's still kind of feeling the way on this new NIL Clearinghouse Go app.
Yeah.
Can you talk a little bit about how this app is going to work and how, if a student athlete is approached with a deal, what do they have? What are the steps they have to take at this point?
Well, I'm going to let you should have a CSC in to talk to you about this thing at that level of detail. What I will say is that the point behind this is to establish some mechanism that creates a process around both the nature of the settlement itself. The injunction creates a set of standards that a third-party NIL proposal needs to meet. And it's going to be up to the CSC to make the decision about whether or not a particular deal does or doesn't live up to the standards that are associated with the settlement. And if there's a disagreement about whether or not it does, there's an arbitration process as part of the injunction, and the person or the firm that whose deal doesn't get approved has the ability to take that to arbitration. The arbitrator can do fact-finding. It's a very traditional standard act in many parts of public life. And then the arbitrator will render a decision one way or another about whether or not it's approved. And the arbitrators who work in this case have been approved by the NCAA, the CSC, and the court and the plaintiffs.
So part of the NIL, the clearinghouse, has been that the booster, let's talk about the boosters right now and the collectives. And I think you were hinting at it a little bit, if I'm correct, on like the third parties that haven't been regulated, but have been an important part of getting payments to student athletes until the structure's been in place. What role do you see for the boosters and collectives now under this new structure?
Well, they're defined in the structure. If you're an associated entity under the injunction, you can participate in this. And there's a certain set of rules and standards and processes and procedures that you need to meet to play. And I think that's probably, again, a good thing. Because what the settlement does is it separates what we think of as a traditional third party from an associated entity, the associated entity being more like the booster.
Okay. So if boosters right now approach a student athlete with a deal that could be on top of the money that they're going to receive, whatever.
From the school.
Right, so
Yeah.
on top of that. I mean, it's a way to basically get student athletes even more money than the university can give them. We have some powerhouse universities that have huge booster programs. How does this not end up putting smaller schools that don't have as big a booster program, how does it disadvantage them? Is that going to create more inequity?
I'm one of these people who thinks at the end of the day, transparency is a better way to handle this than the way we do it now. So you said to me at the beginning, like, what do I like about this? The first thing I like is the transparency. Because in the absence of transparency, the question you just asked, we'll never know the answer to. Okay? If we just kept going the way we were going, there'd be allegations, representations, accusations, but none of it would be either countable, aggregatable, or believable. So for me, the most important part about this is it establishes a process and a system that will generate data, which people can then use to make decisions about what's working and what's not. And with respect to the big versus the small, my answer to that one is there have always been big versus small in college sports. It's one of the fun parts about March Madness, right? The Cinderellas. And the reason they're Cinderellas is because most of the time they're not supposed to win. And yet, on occasion, they do. A lot of us thought it was pretty cool that Vermont won the Division I men's soccer championship last year. Not exactly a powerhouse school, but guess what? They turned out to have a pretty good soccer team. I think the answer to the question you're asking is, we'll see. But there's no question that there have always been really big programs and not so big programs across college sports generally, and certainly across Division I. And there's nothing about this thing that's going to dramatically alter the fact that that's going to be the situation, because it's always been the situation. When Princeton makes a run in the basketball tournament, which they did a few years ago, it's a great story. And I personally believe that those kinds of stories will continue to be true in the future because they've always been there. But the thing that makes them fun and interesting and exciting is because we don't expect them. And the reason we don't expect them is because they represent, the breadth of Division I and the fact that there are going to be always big schools and small schools, big programs and small programs. And more often than not, the big ones will play each other, and the smaller and the mid-sized ones will play each other. And on occasion, Appalachian State will beat Michigan, right? I mean, it's been happening for as long as I can remember. But this idea all of a sudden that we're creating something that's suddenly going to create big differences between big and small, it's always been there.
And you're talking about, through this system, you're going to finally have data. But we're at the very beginning of this, and a big part of that data is going to be how much is an endorsement worth? If I'm a small business and I want the Texas quarterback to show up at that small business, how do I determine what the fair market value is for that presence?
And talk to the CSC about that.
Okay.
Yep.
Do you think that your organization should have had a bigger role in determining this? The CSC is kind of off on its own island, and is it limiting your ability to influence or regulate college athletics? Because how athletes are paid is going to be a huge part of this moving forward.
Well, part of what I like about this is the fact that it's inside an injunction. So, yes, college athletes are going to be compensated. There's going to be a third-party NIL process and an institutional NIL process. This is going to be done inside an injunction with the plaintiff attorneys paying a lot of attention to what's going on and the court magistrate who's assigned to this paying a lot of attention to what's going on. And that arbitration process will be there to deal with disputes. It's a far more structured and legally stable environment than the one we've had historically.
But it sounds
way
like
more.
It's going to be a very litigious one, too.
No, it's an injunction. It sits inside an injunction. This has already been proved by the federal court as a way to, quote unquote, do business here. That's a huge step up from where we've been. I mean, historically, the way this works is one lawsuit at a time spread across years and years and years where millions of dollars get spent on attorneys, and the end game may not even turn out to be something that can be thought of as a holistic solution to a problem. This, to me, is a far more stable and reliable process than anything we've had before. And I think that's a big step up from where we've been.
Okay. Well, we're obviously lucky enough to have you here at the Press Club today. And I just want to ask, what's bringing you to DC? What legislation are you working on or working with lawmakers on?
So we've spent a lot of time talking to people on both sides and in both branches about really just three big issues for us. One is the employment issue. The second is the proliferation of state laws that are basically designed to give schools in particular states a leg up over other schools in other states, which is a problem not just for the NCAA in terms of a level playing field around competition, but it's a problem for conferences too. And the third piece is some sort of limited liability protection that makes it possible for us to enforce our rules. And the best example I can give you for that one, and by the way, all three of those things are in the SCORE Act, which was just marked up and approved yesterday by two of the three committees that have jurisdiction for that on the House side, which we think is terrific. The limited liability piece, we're not looking for some sort of blanket authorization, but there are certain things that should matter to people when they think about college sports that are either being litigated right now or will be litigated at some point down the road. One is academic eligibility. That's an NCAA rule, and it's among the most important ones we have. I mean, 20 years ago, the NCAA took a lot of grief for the fact that student athletes' performance academically was nowhere near where it should be. People put money, resources, effort, solutions in place, and today, across every demographic and every division, student athletes graduate at a higher rate than non-student athletes. It's one of the real success stories of college sports in the past decade. I fully expect at some point if we don't figure out a way to create some capacity to make rules and sustain them, that this question about whether there should be any sort of academic eligibility standard will come under attack in the courts. And the reason I say that is because another thing that's been around for 100 years, which is 5 years to play for, which is a standard rule in college sports, has always been that way. You build the athletic calendar around the academic calendar, and you give student athletes 1 year for an injury, a red shirt, circumstances, whatever it might be. We've currently involved in, so far, on people who want to overturn having a 5-year to play for standard, 23 lawsuits in the last 6 or 7 months. We're 21-2 so far on those, and we're appealing the 2 that we lost. But this is, you can't, we should not permit the interest in having somebody play a sport at a particular school or play a sport in college for 5, 6, 7, 8, 9 years become a standard. This is supposed to be an opportunity to take advantage of the academic opportunities that this presents for the vast majority of student athletes and the opportunity to get a degree with the financial support that comes with it. And for a very small number, the opportunity to participate maybe at some point in professional sports. But even there, remember, the current guarantee we have around scholarships in Division I is you get to keep your scholarship for 10 years if that's what it takes for you to graduate. And that includes if you go become a pro for 3 or 4 years when you leave school, you still have the opportunity to come back and take advantage of that to get your degree. And these are like bedrock principles that we're litigating because some people would rather have no standards around how this stuff works or how eligibility works. And I don't see how you can have a legitimate college sports system without that. And it's currently, it's up in all sorts of courts all over the country. And that's a problem. We need the ability to do something to sustain the stuff that undergirds the whole system.
It seems like the new ability to compensate student athletes actually incentivizes them to stay in longer because if they're not going to go pro, they're making a pretty good salary working at their, playing for their university.
Don't disagree. So play your 4 years and get your degree. You have 10 years in your scholarship to do that. And if you make some money because the school purchases your NIL or you have some pretty good third-party deals, that's great. But again, you're really talking about 5% of the kids here. The other 95% are going to be playing under what we would think of as a more traditional environment.
Sure. We talked about working with Congress. There's also been some chatter that there might be an executive order coming from the White House that could also give you some governance or guidance. What would you look for in an executive order that you think would add more clarity to this process?
Well, I think part of the reason we've been focused on the 3 issues I just mentioned, the limited liability protection, I say this so many times I forget it once in a while, the limited liability protection, the employment piece, and the dealing with all of the various state laws on this is because those are statutory fixes. You can't fix that stuff through an executive order. I think the president's obviously interested in this stuff. He's come to some of our national championships. He's come to some regular season games. He talks about and clearly likes and enjoys what college sports represents. And we're really grateful for that. But I think our focus for now really needs to be on trying to get this stuff dealt with through the legislative process, because that, at the end of the day, is really the only vehicle that can deal with those issues.
So there's not something that you think an executive order could be beneficial for at this point that would be more beneficial than just going through Congress?
I really think I'm open to thoughts and ideas on this, but I think from our point of view, the real focus for us needs to be on that legislative process.
We talked about the SCORE Act and what it's doing for eligibility and employment. Where are some unanswered issues on specifically the name, image, likeness issues that have come up? And let's say a student athlete transfers from one university to the next, do they continue to own the legacy that they created at their past university, or is this still undecided?
That's a question I don't know the answer to. I think third-party NIL deals, I don't think it matters which school you're at with respect to those. I think if you have an agreement with the school around an NIL proposal, then you're obligated to fulfill the agreement, whatever it is it says, just as the school is obligated. I mean, I was talking yesterday with a number of members of Congress who have been very involved in these discussions, and several of them said to me, look, this thing between the school and the student athlete, that's a contract, and it needs to be treated as a contract, and it needs to be thought of as a contract, and therefore contract law applies to it. So if there are obligations the school has, they need to deliver on those, and the same goes for the student athlete.
So it sounds like they're.
But the third-party stuff could, that sort of thing, that would be up to the third party and the student athlete to decide. If somebody was playing at Texas and they transferred to Penn State, and the third party was an entity whose footprint was in Texas, that might not be interesting to them to have somebody who's at Penn State.
So it sounds like there may not be a congressional fix on some of the NIL issues, and just let that be handled in the courts and in contract law, in your view? I
think that's probably a better place for it, yeah.
Okay. So let's talk about another big issue in college sports. We're weeks away from the start of college football season, and few things have affected college football more than the transfer portal. Now that we're a few seasons into it, do you think that the transfer portal has created unintended consequences and unintended instability? Obviously, there are some college coaches who have been very frustrated by the portal. And do you see any room for fixes?
So, that limited liability thing I was talking about a few minutes ago? We used to have rules around the transfer portal, right? You could transfer once. You could transfer a second time for exigent circumstances. But if you transferred again, you needed to sit out for a year and catch up on your academics. That was basically our policy. One school wanted a student athlete to be able to play right away. Their attorney general filed a lawsuit, said the NCAA's policy was an antitrust violation. And several other AGs hopped on, and poof, away went our rules around transfers. I think the current transfer structure that's in place is a problem. And I think it's exacerbated by the transaction mentality that drives a lot of the agents and third parties in the so-called third-party NIL space. I mean, about a third of the student athletes who enter the portal, we track kids pretty well, and we track student athletes a lot better than most government entities do, because we care a lot about the transfer stuff, because it has an impact on their progress to graduation. About a third of the student athletes who enter the portal don't land anywhere. At least we can't find them, all right? They're not playing a sport, and they may or may not still be in school. But we've tracked some of them down, and I've talked to some of them, and somebody pushed them into the portal with a false promise. And this happens a lot. And this is why this transparency issue to me is so important. If somebody tries to tell you as a young person that you can get into the portal and this is going to be what's available to you on the other side, right now you have no ability to figure out if what they're telling you is true or not. At least if we have data out there that shows what real third-party NIL for somebody like you looks like, you can make a decision about whether or not to believe that. I also think having the schools with a primary relationship with a lot of these young people will probably reduce some of that behavior and some of that traffic, and kids will be able to talk to the schools about what they're being told, which currently doesn't happen. There's a lot of opportunity here to reduce some of that movement, which I think is good. But I think the I think the bigger issue associated with the transfer portal, to me, is less about the number of student athletes who end up in it, but the number who don't end up anywhere as a result of misrepresentation, false promises, and outright lying that is done as part of this process currently. The other thing I would say is that it's kids transfer. You know, when I was in college, which admittedly was a very, very long time ago, the idea of transferring was, I mean, no one did, right? Now, it's no secret that I went to Harvard. I got asked when I was running for governor the second time. I filled out this big survey, all the candidates for governor filled it out. And one of the questions in it was, what's your greatest regret? And I said, my greatest regret was that I went to Harvard instead of Hamilton. Whole box of swag from Hamilton showed up on the front porch the next day. And part of the reason I took the job at the NCAA was because the one place I felt like I belonged at Harvard was the basketball program. And yet, the idea of transferring never entered my mind because I had no insight, no visibility into what was going on other than letters and phone calls, sometimes if you could get on the dorm phone, with friends of mine who were at other schools. Young people now have access to gobs of information about every school, everywhere, anytime in America. And about 30% of all college students transfer at least once during their 4 years. 30%. So for all the talk about the transfer portal, you know, I think the number, 17%, I think, is the number of student athletes who transfer. 17. So it's around half of what, I mean, kids transfer. It's just different. And I think from our point of view, there are things we should be doing to try to make it easier for student athletes to make good decisions. I think there are a bunch of things in the settlement that make that possible. And we should also be trying to, you know, give schools the ability for kids who may or may not have a legitimate offer available to them to be able to have a conversation with them about what it might take to help them stay. And if they go, okay? But to me, the big thing is this number at the end of every year about the number of kids who just don't land.
I want to talk about another consequence of the transfer portal, and that has been the impact on high school recruiting. And for your student athletes that are going through high school right now and being looked at by recruiters, a lot of them won't get the same look or touch that they used to because these universities are going to junior colleges or they're going right to the transfer portal to recruit. Did you see that as a consequence of the transfer portal when it was created, and how can you address it now?
Remember, we had a transfer policy in place when the transfer portal first appeared. We don't have a transfer policy in place anymore, unless you call our policy no policy, which is kind of what we have, right?
Okay.
That's one of the reasons why the settlement matters. It's also one of the reasons why doing something here in Congress about limited liability protection so that we can have a reasonable transfer policy would make a difference. I mean, I worry a lot about what's going to happen to our graduation rates too because of this. I think there's a couple things going on with respect to the high school stuff. And by the way, you want to make it really miserable for kids coming out of high school? Let's just say you can play college sports for 7 or 8 years. I mean, the stuff we're working on here is very much based on this idea that there's an opportunity for young people to play, there's an opportunity for them to benefit financially from that, whether it's through scholarships or third-party NIL or school-based NIL, but we need to make sure that we aren't closing the door for the next generation. And I would be the first to say that I think there's a challenge associated with that, and some of the issues that we're dealing with now are not just about today's students, athletes, they're about tomorrow's student athletes and the ones that come after that. And that's a perfect example of that. Yeah, I mean, yeah.
What kind of fix do you see?
Well, let's launch the settlement, give schools back the center of gravity that they've lost with respect to their ability to support student athletes directly, and create more data so that hopefully we don't have huge numbers of kids jumping into the transfer portal with really bad information about what's truly possible and available for them. And give us some ability to actually establish some rules around transfers that would reduce this constant hunt in the transfer portal for the next whomever.
Okay. So I know we're, like I said, we're not even a month into the settlement, but looking at kind of the overall impact of giving some of that power back to the universities, with this 20 million or 20.5 million cap now, even though it'll increase, for a lot of these schools, the preponderance of that is going to go to college football or men's basketball. How do you make that more equitable, or can you? Is it, are there going to be haves and have-nots in college sports?
Well, keep in mind that the settlement does some other stuff too. One of the things it does is it uncaps the NCAA scholarship limits. We used to have limits on how many scholarships you could issue, and the reason for that was competitive equity. Like if your school wants to scholarship everybody on the baseball team, but you're the only school in your conference that can do that, that was viewed by the NCAA as a problem. So we established a competitive equity problem. So we established this rule that said across every sport there's a limit on how many scholarships you can put out there. One of the things this settlement also does is it gets rid of the scholarship limits. And it's very clear so far, based on what schools have been telling us and what they've been reporting and what they've been announcing, that there are going to be, I think it'll be tens of thousands, but for the sake of argument, we'll just call it thousands for today. There are going to be thousands of new scholarship student athletes as a result of this, and many of them are going to be in women's sports. There's just no question about that. I mean, there are going to be thousands of student athletes who are playing women college sports who don't have scholarships today, who are going to have them starting with the next school year. And every school knows they need to play whatever strategy they have here with respect to their third-party NIL, their scholarships, and other student supports. They need to follow and track the rules associated with Title IX, and they know that. And there's a tremendous amount of conversation that's taking place around that. But I actually think one of the big benefits of this settlement is going to be thousands of women playing college sports who are going to have scholarships this year that didn't have them last year.
So while there was not a Title IX component in the settlement or this cap,
correct,
you are optimistic that Title IX considerations will be handled in scholarships?
They have to. It's federal law. Yeah.
So you think it will create more opportunities? Because there has been some concern that, the bulk of this money will go to men's football or men's basketball or baseball, and kind of leave out some of the, women's gymnastics, women's tennis, et cetera. Do you actually think that, my first question, do you think that's probably going to happen just because that's where the universities already put the bulk of their money? And then two, I guess your remedy.
That's certainly where most of the third-party NIL's gone,
yeah.
Right? I don't know exactly what the schools will do. I mean, some of them talked about strategies and approaches to this, but again, until we actually see the data, we're not going to know the answer. But one of the good things about this, we're going to have data, which we don't have now.
Come back in a year. Let's talk about the data.
Right. Happy to.
That would be great. So another question I had about the NIL and for the compensation and these third parties, and we're already starting to see this a little bit, how do you protect female athletes from the commercial marketplace's kind of tendency to sexualize female athletes? Will there be rules in place to protect their image or to protect their, on what these third-party vendors can do and what can be in an endorsement?
I think that's again, that's for me one of the benefits of giving the schools the ability to have real conversations with their student athletes about these issues, which historically they haven't been able to do. They will be able to provide guidance and advice in a way that they couldn't provide guidance and advice when the third-party stuff was, completely off limits. They're not supposed to ever talk about it. I think that's a real net benefit of the settlement, is that schools will be able to talk to student athletes about all sorts of things, and student athletes will be able to talk to them, which, and I would expect and anticipate that schools would be more than happy to provide their student athletes with advice and guidance and support around stuff like that, which historically they haven't been able to do.
I'll take some of the questions that you guys have submitted. This one comes from Mark Schaft at CQ Roll Call. What is the chance the NCAA will lose control of Division I football and major conference and the major Power Five will set up their own football governance structure?
I think this question's been asked for about 20 years, and I appreciate getting asked this question today. I think one of the benefits of the settlement is it gives the NCAA the ability to focus. First of all, it puts the money issues in a negotiated, consolidated framework that sits inside an injunction with an arbitration process and oversight from the courts, the plaintiffs, and the power conferences. And all the other issues, playing seasons, sports betting, cheating, academic eligibility, eligibility generally, championship construction, all that stuff, that sits with the NCAA. We are currently going through a process, by the way, where we are dramatically streamlining the NCAA's governance model in Division I. I mean, I'm a healthcare and government guy. I've been around some of the most complicated decision-making models anywhere, and I was astonished by how complicated the NCAA's Division I decision-making model was when I got there. And so a lot of that is going to get a lot simpler, and I think that will make it possible for us to deal with a lot of the issues that people have raised about the complexity of our decision-making process. And I think for things like whether it's football or men's basketball or women's basketball or women's volleyball or whatever it is, I think we have a way forward here that can make this work.
We have two submitted questions on transgender issues. And will the NCAA, following the UPenn settlement, not allow transgender females to compete in women's sports?
So President Trump issued a memorandum from the Department of Education shortly after he took office and an executive order around this issue. And we are in full compliance with his executive order and that memorandum of understanding. And that's been true, I think, since February, maybe? I'm looking at Buckley. Was it February that that was issued? Yeah. Okay, yeah.
Okay. So I have a fun one to throw at you. What's your favorite sports movie?
The NCAA is headquartered in Indianapolis. I played basketball in college. I'm not allowed to have a different favorite sports movie than Hoosiers.
Good choice.
And I love it. It's not to say I don't. I have a lot of favorite sport movies.
So that was a really fun one. This one, back to a serious question. You've also been an outspoken critic of sports betting. What do you base that opposition on, and do you think there's a future where the NCAA is more closely tied to the sports betting environment? You know, we're seeing it encroach in basically every sport you can watch on TV now.
So after my appointment was announced, which was in December, and before I started the job in March, I just went out and met with about 1,000 student athletes in and around the New England and Northeast area. And I didn't come into or leave a conversation without somebody talking about sports betting. And it wasn't so much about themselves betting on sports, it was about the pressure, social pressure they were feeling from their classmates to help them make money by prop betting negatively on that student athlete's participation in sports. So, hey, all I need you to do is just miss your first free throw. I don't want you to throw the game. All I want you to do is take the first pitch. All I want you to do is strike out at least once. All I want you to do is don't catch the first pass that gets thrown to you. I mean, the nonsense that is being, there's a real issue with young people betting on sports, period. But you compound that problem with student athletes who are surrounded by, because one of the first things we did, because of all this noise I heard, one of the first things we did was a survey of 18 to 22-year-olds around sports betting when I got to the NCAA. And, you know, basically half of the kids bet on college sports. And so that means campuses are surrounded, student athletes on campuses are basically surrounded by a lot of people who are betting on sports and want them to help them make money. And so one of the things we made a high priority was to get prop betting out of college sports. And we've managed, the hard part about it is you got to go one state at a time, okay? And we've managed to get 4 to eliminate prop betting on college sports. There were maybe, of the 38 states that are where sports betting is legal, I think at this point a little over half now don't permit prop betting on college sports. But the other thing you should know is that we heard so much noise from student athletes participating in a lot of our major championships that we hired a firm to track social media traffic that's directed at student athletes in our championships. And we publish a report on it each year. And it's thousands and thousands and thousands of serious online brutality that gets directed at kids. And in some cases, while we're tracking this stuff during the tournaments, we'll notify the platforms and ask them to shut people off. I don't know why we have to do that. I don't know why the platforms don't police themselves, but that's a question for another day. And in some cases, we end up referring some of the really ugly stuff, whether it's directed at officials, coaches, or players, to law enforcement. And we've actually had circumstances where we've put certain teams in our tournaments into 24/7 police protection for the rest of the time they're in the tournament because of some of the threats that are being directed at them. And if you don't believe me on this, go sit behind the bench at a big-time college basketball game and just listen to the stuff that's being directed from the betting community at young people. It's pretty ugly.
We had one other NIL question on whether, and we touched on this a little bit before, and you said that it possibly be handled more by the courts and in contract law, but Senate Majority Leader Thune had said that he might be open to a federal law on NIL, on name, image, likeness, so that it's not a state by state, you know, some states have certain laws.
Yeah, I think that's great.
You'd welcome that?
Sure.
So that would be in addition to it just being contract law?
Well, it would depend upon what you put into it. The problem we have now is that I think what he's talking about is this idea of state laws that basically are designed to create an unlevel playing field for the teams in their states. For example, you now have a number of states that have passed laws or are considering laws that would exempt NIL earnings from state tax law, right? So that, you could come to my state university and get the same number you get at the state university you're at now, except in our state it's not taxed, so therefore you're getting a 5% increase or 7 or whatever the state income tax law is. I think what Senator Thune's particularly interested in is some of the issues that currently exist that create an unlevel playing field between and among the states. And when he talks about a national standard, I think that's what he's talking about, and I'm all in on that. If he wants to include some other stuff, happy to have that conversation too.
We're in our closing minutes, but completely new topic. Are you considering any further expansion of the college basketball NCAA tournament or any changes to its structure right now?
Yeah. There was a really interesting story. I don't know if there's anybody here from The Athletic, but there was a really interesting story in The Athletic yesterday about a debate between Mike DeSorcy and Seth Davis. Davis was for expanding the tournament, and DeSorcy was against it. And I think they both kind of captured all of the various arguments that go in both directions. For me, there's 2 issues associated with expanding the tournament that matter. One is there are every year some really good teams that don't get into the tournament for a bunch of reasons. And some of the reason, and one of the reasons they don't get in is because we have 32 automatic qualifiers. There are 32 conferences in D1, and their conference champion gets into the tournament. Now, I love that. I think it's great, and I never want that to change. But that means there's only 36 slots left for everybody else, and in many cases, there are teams that are among the 50 or 60 best teams in the country. I don't buy this argument that none of the teams that get left out on the bubble are not good. It's not true. I mean, if you think back 2 years ago, UConn, the only hard game UConn had in the last 10 games of their season was the semifinal game against St. John's in the Big East tournament, which I thought they were going to lose. St. John's had a couple of terrible losses early in the year. They had a great team at the end of the year. They didn't get into the tournament. They should have been in it. Indiana State, one of the most fun basketball teams to watch a few years ago, lost their tournament conference championship to Drake, didn't get into the tournament. They ended up going to the final in the NIT. That was super, but they should have been in the tournament. And so my view on tournament expansion is it's a way to not only preserve the importance of the AQs and the real Cinderellas, who in many cases get into the tournament, but it's also a way to make sure that some of the 65 best teams in the country that get left out because of the 32 AQs find their way in. And I don't think it's a big money maker. I've heard several people say, well, it's all about making money. I think all we really want to do there is cover our costs. The big challenge associated with it is sort of the logistical one, which is the tournament has to start after the conference championships are over. And right now, Selection Sunday happens like 2 hours after the last tournament game ends. And it has to finish by the Tuesday before the Masters. So it's like, there's not a lot of room there. So any expansion, we're going to have to figure out how to put it in, and then logistically how to make it work. But I don't buy the idea that some of the teams that currently get left out aren't good. They are, and I think that sucks. And I think the committee's conversation about this has been a good one, and I think sometime this fall they'll make a decision.
This has been a fascinating conversation, and I want to say
I'm sorry that you're reading that, because I don't know if that means you mean it or not.
I'm not.
But,
I'm only reading it.
Right there, I can see it. Yeah.
Do you want to read it?
I'm kidding.
It's just to make sure I don't forget to thank people. So with that in mind, I do want to thank our headliners team, Chair and NPC President Jen Judson and Frank Massano, who assisted with this event, as well as our club's executive director, Didier Sawy, and the entire club staff who worked to make this possible every single time. As usual, we have a Press Club mug for you.
Oh, cool.
You've answered all our questions, so we give you coffee.
Afterward.
After.
Yeah,
Right. You can fill it with the coffee.
Thank you. Thank you very much.
Thank you so much for being here with us today for this informed discussion. I know so much of this is still brand new, and we look forward to you coming back after you have that data.
I'd be happy to come back, and I really do appreciate the chance to be here. And you know, as somebody who comes from a family of student athletes and was one myself, I really do believe it's one of the most valuable human potential development machines we've got, and I hope we don't forget that. I just, you know, this is just a quick story if I have 2 minutes. I meet with a lot of young people all the time, and I was at the Women's Final Four last year, and I met with a bunch of women basketball players, and one of them raised their hand and said, "Can you help me understand how I can use my experience as a student athlete in a job interview?" And I said, "Well, can you take constructive criticism without losing your mind?" And she said, "Yeah." And I said, "Are you willing to put aside some of your own personal interests for the pursuit of the team?" And she said, "Of course." And I said, "Do you understand that, you know, sometimes you gotta love the grind to get better?" "Well, yeah." I mean, she was literally like getting impatient with me. And I asked her like a whole bunch of these kinds of questions, and I say this all the time. I don't think student athletes a lot of the time even understand what it is they're learning by playing a sport and being part of a team and going through the agony of getting knocked down and having to get back up, and the determination that's required to actually get better, and the self-reflection and humility it requires. And I just kept asking her these questions, and I finally just looked at her and I said, if you just talk about those things in a job interview, I promise you, you're going to get a call back, because those are the skills innately that you're developing by playing sports that will make you somebody who somebody wants on their team. And I think it's, I don't think it's a coincidence that Ernst & Young did a study a few years ago that showed that 90% plus of the women in C-suites in America were former college athletes. I mean, you learn playing a sport, and I hope we never forget that, and that's a big part of why I took the job in the first place.
Thank you very much.
Okay, thank you.
See you again.